And last but not least, I'd like to introduce you to our presenters in the area of regulatory and policy development. First, please welcome Hana Vizcarra, staff attorney at Harvard Environmental and Energy Law Program, who will focus her remarks on regulating climate, developments in financial and environmental regulation.
Hello, my name is Hana Vizcarra, and I'm an attorney with Harvard Law School's Environmental and Energy Law Program. I'd like to thank Commissioner Kreidler for leading on climate and for hosting these conversations and inviting me to participate this year. I'm looking forward to learning from all of the speakers today. At EELP, we track and analyze the evolution of environmental and energy regulation at the federal level. I also lead our efforts to understand how the private sector is responding to climate change and the environmental challenges of today. So today I'm going to discuss developments in climate-related corporate disclosure and financial risk management, focusing on federal regulatory trends and how the current environmental deregulatory efforts at the federal level affect the potential for future action on climate change. Right now, we've got fires burning in the West and an unprecedented number of storms forming in the Atlantic. And these just highlight the urgency of the calls by investors and others for better consideration of climate change risks in financial disclosures and strategic planning. These topics have gained prominence in the last 5 years as high-profile individuals like Larry Fink and Mark Carney and groups like the Financial Stability Board's Task Force on Climate-Related Financial Disclosures have raised the alarm, provided structure for discussions, and found ways to achieve agreement on general frameworks. On this slide, I've listed some early actions that represent this shift, but much more has happened since. And it really represents a new recognition of climate change's impact on our economy and our financial system. Concern about climate change in the financial sector, and particularly among investors, isn't new, but it's now a regular topic of discussion among mainstream institutional investors and asset managers. There's a recognition that climate change is already having a financial impact on many sectors of our economy, and it's only going to increase in importance for accurate assessments of risk and corporate performance. Corporate responsibility, especially around climate change, really has become its own industry. On this slide, I have some examples of some of the organizations that have been working with companies to navigate these new demands for disclosure and risk management and advocate for these changes, as well as some examples of some of the investor advising firms that have started to incorporate climate-related data into their offerings. The corporate sector has responded to investors' increasing awareness, thanks in part to the significant engagement efforts over the last 5 years. They've been improving their reporting practices, better integrating climate risk into their internal operational risk management and audit structures that feed into their reporting. And larger companies are developing internal carbon prices to estimate the impacts of an energy transition to their business. They continue to make new commitments to reduce emissions, improve disclosures, and invest in renewable energy and other technologies. Recent high-profile announcements include Walmart's net zero commitments and BP's new strategic plan to shift a significant amount of its business out of oil and gas. There's been a ratcheting up of corporate commitments and expectations. As information gathering and assessment around climate impacts improves, disclosure improves, and commitments are continuously reevaluated. I do not want to overstate the pace of progress here. We still have a significant disconnect between the recognition of potential vulnerabilities and actual integration of climate change risks into enterprise risk management. But in the last couple of years, we've really seen the pace of progress pick up. And what may have seemed like interminable talk has turned into real action. The engagement between investors and companies in 2018 seemed almost a never-ending cycle. Investors wanted more and better climate disclosure, but maybe didn't know exactly what they wanted. Companies had to figure out for themselves what might be useful and in what form. And they were relying on the help of a growing number of firms to support this, sometimes giving conflicting advice. But as companies have disclosed more climate-related information, investors have really started to use it. And they've sought additional information. They're incorporating climate-related information into their assessment platforms and partnering with climate data firms and scientific organizations. State Street, BlackRock, and Vanguard prominently feature climate in their communications with companies, and are even committing to vote against boards that don't take adequate action. This is a trend in progress, but it has expanded beyond the investment community. Banks are revising lending policies to limit lending in certain extractive industries, and they're increasingly disclosing their own exposure to climate-related risks with reports that are guided by TCFD's recommendations. We've seen a wave of announcements from banks in the last year along these lines. Again, there's still a long way to go, but this is no longer the purview of niche impact investors. It's part of the mainstream of financial and investment analysis and risk management. So we're on slide 6 now, and I haven't really talked about regulation yet, which is supposedly the topic of my talk. But that's because so far in the US, the action really hasn't been at our financial regulatory agencies, at least not at the federal level. While regulators in the UK, EU, Australia, New Zealand, and others have started to develop and implement new disclosure and financial risk management requirements around climate-related information, the US has yet to make any significant regulatory challenges. However, the pressure is growing, and we're seeing serious consideration of the role of the financial regulators in managing climate change risks. That said, there's not a cohesive voice among the federal financial regulators about how to address this challenge at the moment. Let's start with the SEC. Most of the focus has been on them so far because disclosure is really the bedrock upon which other regulatory and financial decisions depend. In 2010, the SEC released guidance on the materiality of climate-related information. That was after investors, environmental groups, and the New York Attorney General petitioned the Commission to do so, and after investigations into power company disclosures by the New York AG led to settlements that required those companies to disclose specific climate-related information in their SEC filings. But the 2010 guidance largely sidestepped the question of how companies should handle climate-related information. It provides some examples of information that could be material and thus require disclosure, but didn't really explain what it expected of corporate management. And they failed to follow it up with substantive enforcement efforts. There was little change in the few years after the guidance in corporate disclosures. An effort to evaluate how companies made their materiality determinations could have better defined when climate-related information is material and encouraged more substantive corporate evaluations. In 2016, the SEC again opened a door to new regulation in a concept release that specifically requested comment on whether to require additional disclosures specific to climate change. While the SEC has recently updated certain environmental disclosure requirements, like increasing the dollar amount that serves as a threshold for reporting environmental litigation, it hasn't issued more specific guidance on climate-related disclosures to date. But the SEC is facing pressure to act. Academics have proposed numerous revised reporting requirement frameworks, and its own investor advisory committee has recommended action. And its asset management advisory committee is now considering the climate reporting issue. However, recent statements by SEC commissioners have pushed back on calls for new guidance or requirements. They've generally argued that ESG or climate change specific disclosure requirements are unnecessary because companies already have an obligation to disclose material information. And that's true. The disclosure obligations are connected to materiality. And as investors ask for, use, and rely on more climate-related information, it becomes material for more companies, and disclosure obligations change with or without SEC's guidance. But it largely misses the point that companies need help determining how to properly disclose risks that are rapidly becoming financially material, but are distinct from the kind of information they typically include in their financial analyses. Additional guidance may be all that's needed, but it's clear that there remains substantial concern among issuers about when and what climate-related information is material, and among investors about whether they are really getting a full picture of material information from current corporate disclosures. If the SEC doesn't provide additional guidance, the guideposts may be set by courts, and the process will be much less efficient for the market. While the SEC resists action on climate-related disclosures, the Department of Labor has moved to create potential barriers to ESG-focused funds. President Trump issued a directive to the Department of Labor in 2019 to review data on employee retirement income security act plans and identify trends in investment in the energy sector and review guidance on fiduciary responsibilities for proxy voting. In June, the Department of Labor proposed amendments to the investment duties regulation that discourage consideration of ESG factors like climate in ERISA-covered plans, emphasize financial outcomes above all else, and restrict the ability of fiduciaries to offer ESG-themed funds as default options. And it also required potentially burdensome documentation. This proposal may dampen recent enthusiasm for ESG-focused investments and could discourage integration of topics like climate change in investment decisions, but it doesn't preclude such integration. The proposal explicitly recognizes that the potential financial materiality of ESG factors. Asset managers like State Street have come out against the proposal, and at this stage, it's not final, so we'll see what happens in this administration. But not all financial regulators have taken such a dim view of climate change risk management. Financial and bank regulators with substantial independence from the White House are assessing climate-related risks to the financial system. The CFTC's Market Risk Advisory Committee commissioned a report on climate-related systemic risk that was released in September. It's a broad effort to consider systemic financial risk of climate change and provides recommendations for financial regulators. The Federal Reserve Chairman Jerome Powell has said that the Fed has a role to play, quote, to ensure that the financial system is resilient and robust against the risks of climate change. And the Fed is working to do so. They've indicated an interest in joining the network of central banks and supervisors for greening the financial system. The Federal Reserve Bank of San Francisco hosted a conference on climate change in 2019 and commissioned a series of papers on the topic. And Kevin Storeau of the Federal Reserve Bank of New York has spoken openly on climate change and risk management in bank supervision, and he serves as the co-chair of the Basel Committee on Banking Supervision's high-level task force on climate-related financial risks. He said that the Fed is devoting a lot of resources to climate change risk research. They're closely following central banks and regulators in other countries who are developing stress testing and additional disclosure requirements. CFTC's report includes a long list of recommendations for financial regulators to better address systemic risks of climate change. These include disclosure, risk management, and oversight recommendations. On this slide, I include just a few in summary, but they also include specific recommendations for insurance regulators. Climate change is already impacting how we live our lives and how companies do business. As we've seen, when that happens, it impacts the law. Even without regulatory changes, expectations of how companies and financial entities address climate change have changed. We've already seen a few court cases involving climate-related disclosures, and we're likely to see more. Guidance for auditors is changing as well, and this will influence financial reporting even absent express obligations from the regulatory agencies. Infrastructure development, real estate, and insurance are areas that have had to adjust to very real climate-related impacts. Recent research calls into question the future of the 30-year mortgage in many areas of the country. FEMA flood maps that insurers, developers, and local governments rely on don't fully reflect expected climate risk. Some have started to develop their own sea level rise and flooding data with more up-to-date climate science and projections. So what are the implications of these divergent approaches that we're seeing among the financial regulators at the federal level? Well, these different approaches among regulators may sow unnecessary confusion and slow the progress that could come more swiftly with a more cooperative approach among the relevant federal agencies. But a lot of work is happening, both in states, like in Washington, but also at the federal level. It's just contained to certain pockets rather than being uniform across the administration. I'm going to take a few minutes now to step back from financial regulation and talk about the broader environmental regulatory agenda that we've seen play out under the current administration and what that could mean for future climate efforts. Beyond independent financial regulators, the federal government is not currently working to integrate climate change risks into its legal frameworks. And in fact, it seems to be doing just the opposite. The administration has prevented better integration of the collective scientific knowledge on climate change into the federal regulatory process, undermining reasoned analyses in the rulemaking process. Consistently, it's worked to roll back existing environmental standards, emphasizing regulations designed to address greenhouse gas emissions. At ELP, we are tracking between 80 and 100 individual actions by this administration to weaken environmental regulation, both on our regulatory rollback tracker pictured here and on our EPA emission tracker. Many regulatory proposals in the last few years have incorporated legal interpretations designed to limit the federal government's authority to regulate climate change and environmental protections. Major rollbacks of Obama-era climate regulations included the eliminating oil and gas methane standards. This is one of their most recent actions. That also had a new interpretation of the Clean Air Act that would make it harder for EPA to regulate emissions of other new source categories and impose emission standards for other pollutants. They've also rolled back the clean cars rules that were finalized under the last administration and California's ability to establish more stringent standards. The Affordable Clean Energy rule that replaced the Clean Power Pool rule plan is also a significant rollback of protections and emissions reductions. And the reversal of the appropriate and necessary finding for the mercury air toxic standards is another significant example. In all of these examples, EPA's own evaluation found that their changes would result in emissions increases over the previously standing rule. In many of these cases, the rule changes short-circuited climate-conscious efforts by the private sector, rolling back regulations that they had already complied with or voiced support for. For example, some of the requirements in the VOC and methane standards rule that had been in place as far back as 2012, and the industry was well on its way and already in compliance with most of them. Major oil and gas producers told the administration they didn't want the standards to be rolled back and even submitted public comments to that effect, and yet they did so anyway. Why? Because if their new interpretations of the Clean Air Act included in this regulation are upheld in court, the Trump administration could successfully limit the tools of future administrations to address climate concerns through Clean Air Act regulation. And just to summarize what all of this means, the apparent deregulatory agenda is focused on weakening environmental standards, but there's really no cohesive climate agenda and financial regulation at the federal level right now. We're seeing two different directions pulling from both the SEC's and Department of Labor and the CFTC and the Fed. But that could change in a new administration. Even so, even if it does, it would have to contend with the limiting aspects of some of the other actions taken during this administration in order to make progress on climate and environmental regulation. It could potentially make progress more quickly in financial regulation. So I'd just like to thank everyone for inviting me here today, and look forward to hearing from the rest of the speakers.
Thank you, Dr. Vizcarra. We're taking virtual questions in the chat area and on our LinkedIn event page posted in the comments section. Visit the page later to view answers, ask additional questions, and join in the discussion.